Tonight, if you died in your sleep, your family could not touch a single dollar in your bank account. Not tomorrow, not next week. A will would not help them. A notary would not help them. A notarized, attorney-drafted estate plan would not help them. There is one free form, one that fixes this completely. And the reason most people are never told it exists is simple. Nobody whose paycheck depends on the current system has a reason to explain it to you. Here's the number that should worry you. Most states freeze bank accounts once the balance crosses somewhere between $50,000 and $100,000. And if you've spent decades working and saving, there's a good chance your account already sits above that line. Once it does, your family doesn't just wait a few days. In most states, the law builds in a mandatory 3 to 6 month creditor waiting period before a single dollar can move. And once the court gets involved, that window can stretch well past a year. Meanwhile, the funeral bill doesn't wait. The credit card interest doesn't pause out of respect. The FDIC confirms every insured bank in the country is required to offer a free fix for exactly this problem. Most account holders have simply never filled it out. If that surprises you, hit subscribe, because every week we break down exactly what the Social Security Administration, the FDIC, and your own bank are not explaining to you in plain English. And we make sure you actually understand it before it costs you money or costs your family time they don't have. This is the one video you'll want your kids to watch too, because when this goes wrong, it's usually them standing at the counter, not you. Segment 1. Why your will does not control your bank account. Here's what almost nobody tells you when you sit down to write a will. Your will controls your furniture, your car, your jewelry, the physical property sitting inside your home. It does not control your cash. Bank accounts run on a completely separate legal track, one built on contract law, not estate law. The contract you signed with your bank, not your will, not your trust, not your attorney's estate plan, decides what happens to that money the second you die. A signed beneficiary form at your bank overrides a notarized, witnessed, attorney-drafted will every single time, without exception. If there's no beneficiary named on that contract, the account doesn't transfer to your children. It transfers to your estate. And the moment it transfers to your estate, probate opens automatically. The court-supervised process of validating your will and releasing your assets on the court's schedule, not your family's. That distinction sounds small. It is not. It is the entire difference between your family accessing money in a matter of days or waiting the better part of a year while bills keep arriving. Picture a retiree we'll call a typical case. Someone in their early 70s, comfortable, careful with money, who sells a home and deposits the proceeds into a standard savings account. She hires an attorney, pays several $100s, and walks away with a will naming her 2 adult children as equal beneficiaries. She assumes it's handled. It is not. She never filed a beneficiary form at the bank itself. When she passes, her children arrive with a death certificate and a notarized will, and the bank tells them there is nothing they can do. The will is a letter of instruction addressed to a probate judge. It carries no authority at a bank counter. The account sits frozen while a funeral bill lands in the mail, and the family reaches for a credit card to cover it. While their inheritance sits untouched, a few feet away, behind a counter they cannot legally cross. Segment 2. The 3 ways people accidentally lock their own money. Failure point 1. No beneficiary designation at all. This is the most common one we see. You opened the account years or decades ago. Nobody at the counter asked you to name a beneficiary. You assumed your will would cover it. It won't. Most estate attorneys draft wills. They don't file bank beneficiary forms. Those are 2 separate documents, filed at 2 separate institutions, and almost nobody explains that distinction when you're writing the check for the estate plan. For a retiree living on a fixed income, a 6-month probate process on a modest account can quietly consume a meaningful share of that balance in filing fees, attorney costs, and mandatory legal notices before a single dollar reaches the family. Failure point 2, an outdated beneficiary. This one is more dangerous than having none at all because it feels handled. You name someone 20 years ago, an ex-spouse, a parent who's since passed, a sibling you've lost touch with. That name is still sitting on file. That is who the bank pays, regardless of what your current will says, regardless of how many years have passed since you last thought about it. Courts have upheld this again and again, ruling against surviving spouses and adult children who assumed a newer will would win. It doesn't. The bank looks only at the form on file, not the document sitting in your lockbox. Failure point 3, the joint ownership assumption. A lot of married couples assume everything automatically passes to the surviving spouse simply because they're married. In many states, that's not true unless the account is specifically titled with rights of survivorship. And here's the trap hiding inside the most common attempted fix: adding an adult child directly onto the account as a joint owner. The intention is almost always good: quick access to help pay bills if something goes wrong. The legal consequence is severe. The moment your child is added as a joint owner, the law in most states treats that money as partly theirs, immediately, while you're still alive and perfectly healthy. If your child is sued after a car accident, faces a divorce settlement, or owes back taxes, your savings can be pulled into it, including by the IRS. Joint ownership doesn't just share access, it shares your exposure to every liability your child carries. Segment 3. The free fix and the blind spot most people miss even after they file it. The form is called a Payable on Death Designation, or POD. It is not a will. It is not a trust. It is a direct instruction to your bank that operates on that same contract track your will can't touch, which means it skips probate entirely. Your named beneficiary shows up with a certified death certificate, the bank verifies it, and the transfer processes. Smaller banks often handle it same day or the next business day. Larger institutions typically take 3 to 5 business days, not months, not over a year. It costs nothing to file and nothing to maintain, because every FDIC-insured bank in the country is required to offer it, and every federally insured credit union offers the equivalent. Here's the open loop we mentioned earlier. The blind spot even people who've already filed a POD form usually miss. Filing one does not automatically protect everything you own. Each account is its own separate contract. Your checking account, your savings account, and every individual CD you hold. Even sitting at the very same branch, each need their own POD filed separately. One form does not blanket cover them all. Brokerage accounts use a completely different form called a transfer on death, or TOD, filed with your brokerage firm, not your bank. If you hold stocks, bonds, or mutual funds with no TOD on file, those assets go through probate exactly like an undesignated bank account. Retirement accounts, IRAs, 401ks, 403bs, already transfer outside of probate by federal law. But most people filled that beneficiary form out decades ago and never revisited it. Under federal law, that designation controls over any conflicting will or divorce decree. If an ex-spouse from 1995 is still listed on an IRA you opened back then, they can legally collect the entire balance, regardless of your current will, regardless of your divorce agreement, regardless of how many years have passed. And one more overlooked corner: your safe deposit box. Federal regulations require banks to seal a box the moment they're notified of a death, and the spare key sitting in your child's drawer grants nothing after that point. If your will happens to be sitting inside that box, your family faces a genuine catch-22. They need the will to open probate, but they need a probate order to open the box. The fix costs nothing. Add your child as a joint renter directly on the box's rental contract now, while you're both able to sign together, and they keep access regardless of what happens to you. Segment 4. What to do this week. 1. Go to your bank, in person or through your online portal, and ask specifically for the Payable on Death Beneficiary Designation Form. Every FDIC-insured bank is required to provide it. If the teller doesn't recognize the term, ask for the branch manager. 2. Name a primary beneficiary using their full legal name, date of birth, and social security number. Not my children, not a nickname. The social security number is how the bank verifies identity at the time of transfer, and without it, payout can be delayed. 3. Name a contingent, backup beneficiary. If your primary beneficiary passes before you and no contingent is listed, the account defaults straight back to your estate, and probate opens right back up. 4. Submit the form in person if you can, and request written confirmation that the designation was recorded. Keep that confirmation with your other important documents. 5. Check every account separately. Your checking, your savings, and each individual CD all require their own designation. 6. Contact your brokerage firm and file a transfer on death designation for any non-retirement investment account. 7. Review your retirement account beneficiary designations directly through your plan administrator and update anything outdated immediately. 8. Revisit every designation every 3 years or after any major life event, a death, a marriage, a divorce, a new grandchild. Quick recap, because this matters enough to say twice. Your will does not control your bank account. A separate contract does. There are 3 common ways that contract goes wrong. No beneficiary on file, an outdated beneficiary still sitting there from decades ago, or an unprotected joint ownership setup that exposes your savings to someone else's lawsuits or debts. The fix is a free Payable on Death form your bank is legally required to offer you, but it only protects what it's actually filed on, which means your CDs, your brokerage accounts, your retirement accounts, and your safe deposit box each need their own separate attention. Tonight, your family still cannot touch that money. That stays true until you file this form. It costs nothing. It takes about 10 minutes. Go to your bank this week, ask for the Payable on Death form by name. And if this helped you, subscribe and share it with your kids, because odds are they're the ones who'll be standing at that counter someday.